Okay, today we're going to talk about the 14th Amendment. Over the next couple days, we'll be taking a deeper look at a constitutional amendment that remains critical in protecting both civil rights and civil liberties. 14th Amendment. Why is the 14th Amendment so important? It is, first of all, we need to establish it's not part of the Bill of Rights. It's not one of the first 10 amendments. This amendment is one of the so-called Civil War amendments, added to the Constitution to protect the rights of formerly enslaved people. The 13th Amendment prohibits slavery. The 14th Amendment prohibits states from denying people their rights and guarantees people equal protection of the laws. 15th Amendment prohibits states from denying people the vote based on race. So here is the 14th Amendment, Section 1. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States, and any of the states wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. There are two clauses that are very important when it comes to protecting civil liberties and civil rights: the Due Process Clause and the Equal Protection Clause. First, we'll talk about the Due Process Clause. Nor shall any state deprive any person of life, liberty, or property without due process of law. That's the Due Process Clause. How would you put this in plain modern English? Due Process Clause prevents states from denying people life, liberty, or property without the due process of law, and it is a key protector of civil liberties. Let's clarify some terms. Due process of law is referring to a fair trial under fair laws. Liberty is referring to any of the freedoms listed in the Bill of Rights. For example, freedom of speech, freedom of religion, the right to bear arms, etc. So now let's take a look at the Fifth Amendment versus the 14th Amendment in terms of due process. Keep in mind that the Fifth Amendment already prevents the government from taking away our rights to life, liberty, and property without due process. However, the Fifth Amendment only applies to the federal government. It does not apply to the state governments. Initially, the Bill of Rights only applied to the federal government. The states were free to take away your liberties without due process. The founders incorrectly assumed that the state governments were closer to the people than the federal government and thus would be less likely to take away their rights. So they didn't need to set up a Bill of Rights that the states had to follow. An incorrect assumption, as we've seen over the years. So then we have this process called selective incorporation. Once the 14th Amendment was passed, which clearly, let's go back to the wording so we can see it very clearly. The 14th Amendment clearly tells the states that they cannot deprive any person of life, liberty, or property without due process. It's directly addressed to the states. And so, but even so, that got passed in the 1800s, states still pretended like it didn't exist. And so what we've had over the course of over a century is this process called selective incorporation. Even after the ratification of the 14th Amendment, the entire Bill of Rights were not automatically honored by the states. They basically pretended that they didn't have to follow the 14th Amendment. So the different liberties in the Bill of Rights have been applied to the states on a gradual, case-by-case basis. This process is called selective incorporation. So one case at a time, the people of states have sued the states for their rights as spelled out in the Bill of Rights, and it's taken almost 2 centuries for some of those rights to be fully applied at the state level. Some samples of selective incorporation cases, Gitlow versus New York, which was in 1925, held that the states can't deny people their First Amendment right to free speech. Before this case, states pretended like they could do whatever they wanted with our free speech, even though the federal government had to honor our free speech, right to free speech. Gideon versus Wainwright in 1963 held that the states can't deny people their Sixth Amendment right to an attorney. Again, states basically behaved in such a way that they pretended it wasn't in the Constitution that we had the right to an attorney until this Supreme Court case where the Supreme Court upheld that states couldn't deny this right. And then in 2019, Timms versus Alabama held that the states can't deny people their Eighth Amendment right to be free from excessive fees and fines. What do you notice about the timeline here? Okay, now we're going to interpret this political cartoon, and we'll take a look at it. Since it's a little small, we'll take a look at it piece by piece. So here, what is the Bill of Rights doing, and what is the Bill of Rights not doing? And in the second image, with the help of the 14th Amendment, what is the Bill of Rights doing? And so what exactly is the message that the artist of this political cartoon is trying to communicate? Okay, now we move on to the Equal Protection Clause of the 14th Amendment. And it states, that the states cannot deny to any person within its jurisdiction the equal protection of the laws. How would you put this in plain modern English? The Equal Protection Clause prevents states from passing laws that discriminate against certain groups of people. This mainly protects civil rights. Different social movements have used this clause to campaign against discrimination on the basis of race, gender, sexuality, etc., and to seek the protection of equality of opportunity. Examples of Equal Protection Clause cases, again, cases that slowly incorporated the protections of the 14th Amendment and the Bill of Rights to individuals in states' jurisdiction. Regents versus Bakke, which we've seen before, which the Supreme Court ruled that quota-based affirmative action programs violated the Equal Protection Clause. And Hoyt versus Florida, in which the Supreme Court in 1961 found that a Florida law prohibiting women from serving on juries violated the Equal Protection Clause, thus requiring the states to recognize equality of opportunity for both genders. And Obergefell versus Hodges in 2015, as recently as 2015, the Supreme Court found that prohibiting same-sex couples from getting marriage license violated the Equal Protection Clause.